Swayam Prabha. Digital India. Educated India.
Well, students, this is Dr. Ajay Kumar Singh, Assistant Professor, Faculty of Law, BHU. So, this is my third lecture which I am going to present before you. So, today's topic of discussion is role of judiciary in protection of human rights. So, in this session I would like to highlight few important judicial pronouncement. With the help of judicial pronouncement, we will try to understand that how Supreme Court has been effective in protecting human rights of the citizen of this country. As you all might be knowing that all the people of this country have certain rights, certain fundamental rights, and those fundamental rights are guaranteed by the supreme law of the land, that is Constitution. Constitution itself recognizes certain rights as a fundamental rights, and fundamental rights which we have seen in the part 3rd of the Indian Constitution. You all might be knowing that in 1948 United Nations General Assembly passed a resolution in order to provide basic rights to the citizen across the globe. So, every human being is born equal. Every person has certain rights because of human being. So, with this notion, General Assembly in 1948, United Nations General Assembly in 1948 passed a resolution, that is UDHR, Universal Declaration of Human Rights 1948. So, that declaration specifically talks about certain basic rights, certain human rights, and those human rights are recognized in our legal system, and those human rights have been duly recognized in part 3rd of the Indian Constitution. For example, right to equality, every person is equal in eye of law, irrespective of caste, creed and religion, every person is equal in eye of law. Right to equality, that is human right provided in UDHR. Article 1 of that UDHR specifically talks about right to equality. Article 3 of that UDHR talks about right to life. Every person has right to live with human dignity. So, that right to life has also been recognized in our legal system, and in part 3rd of the Indian Constitution, right to life is guaranteed under Article 21 of the Indian Constitution. 21 of the Indian Constitution specifically talks about right to life or personal liberty. So, I am referring that provision, Article 21 of the Indian Constitution: no person shall be deprived of his life or personal liberty except procedure established by law. Meaning thereby, every person has right to live with all human dignity, but even right to life, that is precious right, one important human right, Article 21 of the Indian Constitution does not recognize this right in all circumstances. Even this right to life is not absolute right. If someone has, suppose if criminal or offender who himself has committed crime, a murderer, a person who himself has killed somebody is murderer, he has committed murder. So, that murderer has no right to live, because Article 21 specifically talks about that no person shall be deprived of his life or personal liberty except procedure established by law. Meaning thereby, by prescribing certain procedure by law, this life, anyone can be deprived from this precious right if someone has breached the law. So, breach of law will not protect a person to live in all circumstances. This right to life will not be available to that person who himself has committed murder. So, his life can also be taken away by the law, and you all might be knowing that the punishment for murder is provided in Indian Penal Code section 302 of the IPC. Indian Penal Code specifically talks about whoever has committed murder may also be awarded death sentence or life imprisonment. So, death sentence, death penalty is a kind of punishment which can be awarded by the court, criminal court, if court is convinced that someone has committed murder. So, in that case you see article 21, you must see this provision in the light of section 302 Indian Penal Code. So, right to life, though right to life is also fundamental right to life is also human right, but this right is not absolute. If someone has committed murder, he can also be punished, his life can also be taken away. If he is habitual criminal, habitual murderer, then his life can also be taken away by the government. So, this thing you need to understand, right to life, right to equality. But in this lecture I would like to highlight only those human rights which are directly connected with criminal justice system. As I have already been emphasizing on the system of criminal justice system, as you all might be knowing that there are three vital component of criminal justice system: police, judiciary, police prosecution, judiciary and prison. So, we will have to see what is the role of judiciary. Judiciary being important component of criminal justice system, whether this organ has been effective in protecting human rights of the citizen. So, with the help of judicial pronouncement I would like to, but before I start that component I would like to throw some light on those constitutional provisions which empowers the Supreme Court and High Court to protect the rights of citizen of this country. So, with the help of this screen you look at your screen. So, criminal justice system, as I have already highlighted: judiciary, Supreme Court and High Court. Article 32 226, under Article 32 Supreme Court is empowered, under Article 226 so High Courts are empowered. Under these two provisions of the Constitution, Supreme Court and High Courts are considered as custodian of citizen of right. Section 2D, which talks about human right, Section 2D of the Protection of Human Rights Act 1993, that is very important, because without understanding this provision you won't be able to understand the role of judiciary. So, that is why I decided to put this definition on this slide. You see, definition of human right. What rights can be considered as human right? So, according to section 2D of the Protection of Human Rights Act 1993, human rights are those rights which are embodied in the part 3rd of the Constitution or in any international covenant enforceable by court of law. So, with the help of this definition, we can understand that those rights which are guaranteed, which are provided in the part 3rd of the Indian Constitution. So, we simply can say that all the fundamental rights are human rights. So, human rights, we have recognized those human rights as a fundamental right in the part 3rd of the Indian Constitution. For example, Article 14 right to equality, Article 21, Article 19 right to freedom of speech and expression, that is human right, and we have recognized that human right as a fundamental right in part 3rd of the Indian Constitution. Article 19 1A right to freedom of speech and expression. Protection against double jeopardy, protection against self incrimination, right to life, personal liberty, protection against unlawful detention, Article 22, protection against prohibited labor. So, these fundamental rights or human rights provided in UDHR. So, section 2D of this act makes it clear that all those rights which are embodied in the part 3rd of the Indian Constitution shall also be considered as human right, or those rights which have been mentioned in an international covenant. International covenant, as I said, international convention, international covenants are bilateral or multilateral agreement which are binding on state parties, which are binding on those members who have put their signature on that document. So, states are bound to respect those rights to which they have given their consent to adopt in their legal system. So, India too is signatory of that international covenant. So, I would like to highlight two important international covenant here. First is International Covenant on Civil and Political Right 1966, and second is International Covenant on Cultural and Educational Rights 1966. So, under these two international covenants, whatever rights have been recognized may also be considered as human rights for the purpose of this act, statute. These two important things I think that you all have understood. And the third important element of this definition is those rights must be enforceable by the law, by the court. So, if means all the right, you all might be knowing that all the fundamental rights provided in part 3rd of the Indian Constitution are enforceable by the Supreme Court under Article 32, and fundamental rights are enforceable by high courts under Article 226. And you see, Supreme Court and high courts, judges of this Supreme Court and high courts, they take oath to for what? To defend the Constitution and to protect the rights of citizens of this country. So, being custodian of rights of the citizen of this country, judges of Supreme Court and high courts, they are constitutionally bound to protect human rights of the citizen of this country. So, Supreme Court particularly has been effective in not only in recognize several rights as a fundamental rights under Article 21, but also Supreme Court has played important role in protection of human rights. So, I will discuss those judicial pronouncement one by one. Here I would like to highlight few important judicial pronouncement. For example, right to food, right to shelter, right to livelihood. So, these rights have been recognized by the Supreme Court, and with the help of this judicial pronouncement, I would like to, you can look at this constitutional remedies under Article 32. Article 32 of the Indian Constitution specifically talks about constitutional remedies, means rights would be meaningless if remedial system or if there is no effective mechanism for redressal of grievances. So, for that purpose we have adopted effective grievance redressal mechanism under Article 32 and 226. So, Article 32, you say right to move before Supreme Court is a fundamental right. I have mentioned this Supreme Court in brief. Right to move before Supreme Court itself is a fundamental right. For what? For the enforcement of fundamental right. Article 32 clause 2 specifically talks about that Supreme Court shall have power to issue any direction or order or any writs in the name of habeas corpus, mandamus, quo warranto, certiorari for the enforcement of fundamental rights. So, you see, wherever there is violation of fundamental right, Supreme Court will come forward to protect that violation of fundamental right under Article 32 of the Indian Constitution. Either victim can move before the Supreme Court or Supreme Court, you see, Supreme Court itself take suo motu cognizance where fundamental rights are violated by the state or by state agencies. So, Supreme Court itself can take suo motu cognizance and can take appropriate action in that matter. So, as you all might be aware about UDHR 1948, right to life, protection against torture or inhuman treatment, this is also a precious right. protection against inhuman treatment or protection against torture, that is provided in UDHR 1948, and these two things are also considered as important human right in this declaration. So, as per that declaration, you all might be aware that every person has right to be treated humanely, means every person has right to be treated equally, and presumption of innocence is one important human right provided in UDHR. Every person is presumed to be innocent unless his guilt is proved before the court of law. So, presumption of innocence, that is important human right provided in that declaration. So, having all these things in mind, criminal courts have to decide the case that every person who has come before the court or who is brought before the competent authority is innocent unless his guilt is proved before the court. So, having these idea in mind, criminal courts have to start their proceeding. Apart from this, we will have to see that what are those judicial pronouncements where we can say that Supreme Court has played important role, Supreme Court has should be treated as custodian of fundamental rights. The first case which I would like to refer in this lecture is Ruddal Shah versus State of Bihar, AIR 1982 Supreme Court. You just look at your screen, Ruddal Shah versus State of Bihar, AIR 1982. This is the first case where Supreme Court intervened in this matter and protected the right of detainee, rights of Ruddal Shah, petitioner who was languishing in jail for several years. Second important case is Bhim Singh versus State of Jammu and Kashmir, AIR 1986 Supreme Court, and third important case is Khatri versus State of Bihar, AIR 1980 Supreme Court. This case is popularly known as Bhagalpur blinded prisoner case, and I would like to explain the facts of this case one by one. So, let us take first case Ruddal Shah versus State of Bihar, AIR 1980. You see, this case is pertaining to rights of a prisoner, and where Ruddal Shah, I would like to highlight facts of this case. Ruddal Shah, who himself had committed crime and was languishing in jail, but trial court had acquitted. He was acquitted, he was exonerated from criminal liability, but that order was not served to the petitioner, due to which he had to remain in jail for more than 14 years. He was to be released in 1968. He should have been released in 1968, but he was released in 1982. So, you see, he remained in jail for more than 14 years. Since he was not aware about his right, or he was not informed that he had been acquitted by the court, when matter was brought into the notice of Supreme Court directed the government concerned. In this case, state government must provide compensation to the victim of crime. This Ruddal Shah, he himself was not aware about rights which he could have claimed against the government. So, Supreme Court directed the government that he should have been released before 14 years, but because of your negligence or because of the negligence of state authorities, he had to remain in jail for more than 14 years. So, state government is bound to pay compensation, that Ruddal Shah must be compensated by the government, and accordingly government was directed to pay compensation to Ruddal Shah. So, you see how Supreme Court recognized evolved compensatory jurisprudence in this case, that compensation can be claimed as a matter of right wherever state negligence is proved. If it is proved before the court that state authorities are negligent, they have not rendered their services properly, then in that case state government can be held responsible for the violation of human right, and in this case state government was held responsible for the negligent behavior of its representative, its officials. Second important case is Bhim Singh versus State of Jammu and Kashmir. As you all might be knowing, might be aware that petitioner in this case was a member of Legislative Assembly, he was MLA, and when he was going to participate in legislative proceedings, he was arrested by the police, due to which he could not participate in legislative process. As a result of that, he could not cast his vote, precious vote, to whom he wanted to, he could not participate in the house. So, he challenged the legality, constitutionality of his arrest before the Supreme Court on the ground of violation of right to life or personal liberty. He pleaded before the court, though his absence did not affect the constitutionality of proceeding of the house, but he was deprived from his precious right guaranteed under Article 21 of the Indian Constitution. You see what I am trying to justify. The petitioner Bhim Singh in this case pleaded before the court, Supreme Court, that though he is absent, he could not participate in the proceeding, he was absent, and his absence could not affect the legality of proceeding of the house, even though his right was violated. Police officer who had arrested him, they had violated his precious right guaranteed under Article 21 of the Indian Constitution. Considering the facts of this case, Supreme Court held that it was a case of violation of right to life or personal liberty guaranteed under Article 21 of the Indian Constitution. This case is also important in tort. You all might be knowing that in law of tort, there is a Latin maxim that ubi jus ibi remedium, where there is a right, there must be remedy. This is one Latin maxim. The English meaning of this ubi jus ibi remedium is, where there is right, there must be remedy. Second important Latin maxim is injuria sine damnum and damnum sine injuria. Injuria sine damnum means infringement of legal right without damages. Though Bhim Singh, petitioner, he did not suffer any economic loss, but his right was violated. It is a case of infringement of right, and that is why he must be compensated by the government concerned, and state government were directed by the Supreme Court to pay compensation to the petitioner, and Supreme Court held that detention was unconstitutional. So, you see how Supreme Court intervened in these two important cases. Third important case is Khatri versus State of Bihar. So, I think if you all are very serious, you might have seen that Khatri versus State of Bihar exposed the ground reality of police administration of State of Bihar. What actually happened, this case is popularly known as Bhagalpur blinded prisoner case. What actually happened in this case, there were about 24 prisoners who being interrogated by the police, and at the time of interrogation, police officers who were involved in that incident, though they were suspect, all the accused they were suspect, and police officials they were interrogating the case, and during interrogation several accused they lost their eyes permanently. They means police officials, investigating officers, they used a specific kind of chemical in their, they poured a specific kind of chemical in their eyes. Due to that, they 24 accused, they lost their eyes. Matter was highlighted since they were not in position to raise their voice before the competent authority due to poverty or social constraint. They were poor, they were not in position to engage their counsel in the court. So, matter was taken up by a social activist. You all might be knowing that Kapila Hingorani played important role. She is also considered as mother of PIL, public interest litigation. So, she played important role in this case, and because of her contribution all the victims of crime they got compensation from the government. And it was held by the Supreme Court that investigating officers, police officers who were involved in that incident should be prosecuted and convicted for the commission of the crime, as well as state government must pay compensation to those accused who had lost their eyes permanently or they had suffered loss. So, this is another important case where you can see that Supreme Court played important role in protection of human right. This case is also referred in that head in police where police atrocity or custodial violence. Even in that chapter, that head, this case is also relevant. Now, third, you see, with the help of this slide, I want to highlight few more case laws. You see, the fourth case is Nilavati Behra vs. State of Odisha, and fifth case is Saheli vs. Commissioner Police Delhi, Tukaram vs. State of Maharashtra AIR 1979. Nilavati Behra case, that is case regarding custodial death. Saheli vs. Police Commissioner of Delhi, custodial death. Tukaram case, that is pertaining to Mathura rape case. This case is also known as Mathura rape case. You see, Nilavati Behra case, Supreme Court for the first time in 1993, Supreme Court accepted a letter written by petitioner Nilavati Behra, and Nilavati Behra in this case, she was mother of deceased. She had lost her 22-year-old child. He was brutally killed by police in police lockup, and after that incident the body of that deceased was found nearby the railway track. Police officers who were involved in that incident, they tried to convert that case into suicide case, but with the help of postmortem report, and postmortem report revealed that deceased had got multiple injury in vital part of their body, in his body. So, with the help of that postmortem report, Supreme Court reached on conclusion that it is a case of custodial death, and police officers who were involved in that custodial death should be prosecuted and convicted by the government by initiating criminal proceeding against them, as well as state government must pay compensation to deceased mother Nilavati Behra. Petitioner was allowed to get compensation from the state government, and in this case 1,50,000 rupees was awarded as a compensation to Nilavati Behra. So, this is and you see the plight of deceased mother. If you will go through the fact of this case, you will find that even in such kind of violence, government pleaded before the Supreme Court that sovereign immunity should be considered as a good defense, because police officers, they were performing their duties and they were authorized by the law to investigate the matter. So, it should be considered as a case of sovereign immunity, but Supreme Court did not accept the plea of government, and Supreme Court said that it is a case of custodial violence, it is a case of custodial death. Police officers who are involved in this case must be awarded severe punishment, and petitioner must be awarded compensation. So, government had to pay 1,50,000 rupees as a compensation to the petitioner in this case. So, this is important. Another important case on this point is Saheli versus Commissioner of Police, Delhi. You see, this Saheli word is name of NGO, non-governmental organization. In this case, what happened? A 9-year-old child, a 9-year-old boy who was killed in police lockup, and since the mother of that child, deceased child, was not literate, was not in position to engage his counsel advocate before the court. Since he was poor, so due to poverty he he was not in position to pay court fee, or he was not in position to appoint advocate for herself. So, it was decided by that NGO to fight her case, and NGO decided to file a petition in Supreme Court, and Supreme Court took cognizance, and Commissioner of Police Delhi was held responsible in this case. That Supreme Court said that 9-year-old child who was called by the police officer at police station for interrogation, and due to brutality of police officer, 9-year-old child was found dead in police lockup. So, it is a case of custodial death, and police must be prosecuted and convicted for the custodial death. This is another important case which you need to remember. Now, come to this Mathura rape case, Tukaram State of Maharashtra, IR 1979. You see, this is also a situation where this case is also important in Indian Penal Code, in under Indian Evidence Act 1872. This case in case of section 375 Indian Penal Code, and here this case is important in this lecture when human right of the victim of crime was protected by the Supreme Court in 1979. You see what actually happened in Tukaram case. Tukaram was a constable, and Tukaram being a constable, he was obliged to protect the rights of the victim. So, Tukaram, with the help of his guilty partners, on the date of incident, the victim of crime, and her name was, the name of victim was Mathura. She was 16 years old at that time when that incident took place. She was, when she approached the police officer, station head officer was not present at the police station. So, constable was present, Tukaram was present at the police station. Tukaram, he committed rape against that girl. He committed rape with her, and when hue and cry was made by that victim, her brother was also waiting, was standing outside the police station. He was waiting. That Tukaram did not allow her brother to come in police station. When matter was brought into the notice of court, FIR was lodged against petitioner in this case. FIR was lodged against Tukaram, and both Tukaram and his guilty partner, they were arrested when for committing rape with that 16-year-old Mathura. Then when matter was brought into the notice of court, trial court convicted. When matter was appealed, High Court confirmed the upheld the sentence passed by trial court. When matter was appealed by appellant in Supreme Court acquitted him on the ground that it was not a case of rape, it was a consented act, because at the time of commission of the crime there was no medical report showed that there was no scratches found on her body, on the body of victim. So, inference can be drawn that, see, in such kind of situation generally victim has to resist, or means resistance, generally victim has to resist, but in this case medical report reveals that there was no scratches found on her body. So, this case it appears to the court that this is a consented act, and when act is committed with the consent of victim, that act cannot be covered within meaning of rape. So, both were acquitted from the charges of rape. This matter, this decision was criticized, and Justice V.R. Krishnaiyer, who was also who was also present in that bench, in that hearing. So, Justice Krishnaiyer, he was not satisfied, and he gave his dissenting opinion in this case. He said that though he gave his dissenting opinion in this case, he said that in such a situation, in situation like this, court should not assume that scratches should be found on the body of should be present on the body of victim, and in such helpless situation no victim can raise voice, neither she can raise voice, nor court should insist upon scratches or anything must be found on the body of victim. So, to my understanding, means V.R. Krishnaiyer said that to my understanding this is a complete case of rape, and this case should be considered under section 375 of the Indian Penal Code, and both Tukaram and his guilty partner must be convicted. But since you see majority opinion was that this is a consented act, this is not a case of rape, so accused may be acquitted. So, this case, you see this judgment was criticized. Soon after, you see this case was decided by Supreme Court in 1979, and in 1983 Parliament had to make amendment in the law that in case of rape, if victim comes before the court and he pleads before the court that act was not consented act was committed against her will or against her consent, court may presume that it is a case of rape. So, burden of proof lies on accused to prove the case beyond reasonable, means to prove the case is with the consent of victim of crime. So, that amendment was, that provision was amended only because of this decision. So, this is another important case. Now, come to this protection of women's rights. Now, we will try to understand that how Supreme Court has played important role in protection of women's right, women's human right. So, there are two important judicial pronouncement on this. With the help of these two important pronouncement, Vishakha case and Bodhisattva Gautam versus Subha Chakravarti. You see how Supreme Court evolved a new doctrine in Vishakha case, Vishakha versus State of Rajasthan, AIR 1997 Supreme Court. You look at your screen. This case is popularly known as Bhauri Devi gang rape case, and protection of women from sexual offence at working place. This thing was in question before Supreme Court. What Supreme Court issued guideline that women grievance cell must be established in government as well as in private institution. Male can be prohibited to enter into place where women is working. Women can, you see, respondent can be prohibited to enter into the premises of that female who is victim of sexual violence. So, I would like to throw some light on the facts of this case, what actually happened in Vishakha case. You see, this case is popularly known as Bhauri Devi gang rape case. Bhauri Devi, she was a village head, Sarpanch, village head in a village of Rajasthan. So, she had been, you see, she had been involved in raising voice against child marriage. Child marriage at that time was a common practice in Rajasthan. So, Bhauri Devi decided to fight battle against child marriage. So, Bhauri Devi with the help of her team used to go village to village, and with the help of awareness or with the help of her team, she started creating awareness among the society. So, in this case local people, they decided to teach a lesson to the victim of crime, and she was raped by local resident of a village just to teach lesson to the victim. Since this is a case of gang rape, so Vishakha, this NGO, Vishakha is NGO in this case, non-governmental organization. Vishakha decided to fight case of Bhauri Devi, and when matter was brought into the notice, Supreme Court took cognizance of this case, and when Supreme Court asked the state government and central government that whether state government or central government both are having any special legislation for the protection of women from sexual violence at working place, neither state government nor central government did reply to the Supreme Court. State government and central government both stated before the Supreme Court that right now we are not having special legislation for protection of women from sexual violence at working place. We do not have special legislation on this point. So, Supreme Court directed the state government and central government to make legislation, special legislation for the women, for what? For protection of sexual violence at working place, so that they cannot be victimized by the respondent. So, for that purpose Supreme Court said that unless Parliament enacts any special legislation on this point, the guidelines which is being issued by Honorable Supreme Court shall be considered as law for this land, for this country. So, Supreme Court in Vishakha case issued various guidelines for protection of rights of women at working place. So, the first important guideline is Supreme Court said that it is the duty of every establishment, it is the duty of every employer to have internal grievance mechanism, women grievance cell. Every institution, every establishment, whether it is public enterprises, whether it is a government establishment or private establishment, government institution or private institution, every government and private institution will have women grievance cell, internal complaint cell, so that, and the chairman of that women grievance cell must be necessarily a women, so that women, because women can understand the problem of female. So, women grievance cell must be established first. Second important guideline of this case is that a respondent cannot enter into the premises where victim of sexual violence is residing. So, that respondent can be prohibited. So, this you see this this type of guidelines was issued by Supreme Court in Vishakha case, and now Parliament has enacted a special legislation. The name of that special legislation is Protection of Women from Sexual Violence at Working Place Act 2013. So, now Parliament has enacted a special legislation on this point. Another important case on this point is Bodhisattva Gautam versus Subra Chakravarti, EIR 1996 Supreme Court. You see what actually happened in this case. I have highlighted right to compensation under Article 21. Interim compensation may also be awarded to the victim of crime. In Bodhisattva Gautam versus Subra Chakravarti, you see what happened. This case is important from two points of view. First is, this case is important wherein Supreme Court for the first time recognized that fundamental right, if fundamental right is violated by private individual, victim can claim this right against private individual also. First. Second important thing is that rape victim can get compensation from the wrongdoer, from the accused. So, you need to understand two important things in this case, what Supreme Court has observed. The first, you see what actually happened in this case. Bodhisattva Gautam, he was a lecturer in a college, and he convinced Subra Chakravarti that he wanted to marry with this respondent, and he put a proposal before this Subra Chakravarti. Subra, she was also agreed, and when they used to, means they lived as a wife and husband for several years. But after some time, Bodhisattva Gautam, he left her and he refused to accept as his wife. So, being deprived, being aggrieved, she filed a complaint before the court that he cheated her. Bodhisattva Gautam, he cheated her and he committed rape against her. He established sexual relationship against her will, against her consent, against her will. So, when matter came before the Supreme Court held that in this case, this is a case of rape, and appellant Bodhisattva Gautam, who had committed rape against that Subra Chakravarti under delusion, giving false consolation that he would marry with her, and he did not marry. So, he must be prosecuted and convicted for committing that crime, as well as he must be compelled to provide compensation to the victim of crime. So, compensation was also, and Supreme Court said that Subra Chakravarti should be allowed to get compensation, interim compensation from her husband, and husband was also directed to give compensation to Subra Chakravarti. This is another important case. Now, come to right to fair trial. As you all might be knowing that right to fair trial is also a human right recognized in UDHR. In that declaration, as per declaration of Universal Declaration of Human Rights 1948, every accused has right to be tried fairly. Right to fair trial is a fundamental right as well as human right. So, what are the components of fair trial and how Supreme Court has been effective in protecting this right? So, with the help of two important case laws, I would like to justify my argument. You see, there are two important case laws. First is Amar Mani Tripathi versus State of UP. That case is popularly known as Madhumita Shukla murder case. And second important case is this is Jahira Sheikh versus State of Gujarat. Jahira Sheikh versus State of Gujarat, you look at your screen, you look at this Jahira Sheikh versus State of Gujarat. This case is popularly known as Best Bakery case. Best Bakery case. And first case is Amar Mani Tripathi and others versus State of UP. This case is popularly known as Madhumita Shukla murder case. So, how these two important cases have been decided by Supreme Court? You see, in this case what actually happened in Madhumita Shukla murder case, when matter was being interrogated by UP police filed a closure report in this case by stating that Amar Mani Tripathi, neither Amar Mani Tripathi nor his wife were involved in that incident, but the deceased sister, she went in appeal, she requested the High Court, and High Court directed the state government to investigate this matter by CBI. Matter was referred to the CBI. When CBI started investigation, CBI arrested not only Amarmani Tripathi, but his wife also, and CBI submitted charge sheet that both had committed murder of the deceased Madhumita Shukla. Matter, you see, in order to ensure fair trial, this plea was also taken by the deceased sister Nidhi Shukla. She is still alive. So, the deceased sister took plea before the High Court unless this matter would be transferred by Uttar Pradesh to Uttarakhand to any other state, because accused is so influential, he might influence this justice delivery system. So, Supreme Court has power to ensure, Supreme Court under section 406 of CRPC has power to transfer a case from one state to another state. The purpose behind transferring a case from one state to another state is to ensure fair trial. So, in this case, Supreme Court gave direction to the High Court that this case must be transferred from Uttar Pradesh to Uttarakhand, and matter was transferred from Uttar Pradesh to Uttarakhand. And Uttarakhand in Dehradun, means matter was transferred to Dehradun. Dehradun district court decided this case, and Dehradun High Court also upheld the decision of district court and convicted the accused and his wife. So, how you see how in brief I quickly highlighted the facts of this case and the judgment of High Court and means Uttarakhand High Court and District Session Court. You see how the sole purpose of behind transferring this case was to ensure fair trial. Second important case that is Jahira Sheikh versus state of Gujarat. Students, as you might be aware that in Jahira Sheikh case, when all the accused who had committed murder, who had killed 7 people in this case, father of Jahira Sheikh and the workers who were working in Best Bakery, they were killed by a ruling mob, and due to lack of evidence, all the accused who had been named in FIR were acquitted by the district court. The acquittal of accused got sensational news. It became news for this country that all the accused were acquitted by the trial court in the absence of adequate evidence. Matter was brought into the notice of Supreme Court, and then Supreme Court decided to transfer that case from Gujarat to Maharashtra, and Bombay High Court was given direction that Bombay High Court should decide the case. You see how actually that incident took place in Gujarat. So, rule is that where crime takes place, that place is proper place to conduct the trial. So, trial means that incident took place in Gujarat. So, Gujarat was Vadodara district court was the proper competent court to try the case, but it was not possible to ensure fair justice, fair trial, because all the accused were acquitted by the trial court. So, Supreme Court decided to transfer that case from one state to another state, and matter was transferred from Gujarat to Maharashtra. And then when trial was conducted in that state, all the accused who were involved in the incident, many of them were convicted in the same case. Trial court convicted them. Now, come to this another important aspect of role of judiciary in protection of human right. How free legal aid, as you all might be aware that right to free legal aid, right to legal aid, every person must be represented by a legal counsel, every person has a right to get legal assistance from the state, every person has right to engage counsel of his own choice. So, article 22 of the Indian Constitution specifically talks about that every person has right to have a counsel of his own choice. Similarly, section 303 of the CRPC talks about legal representation, that every accused has right to engage his counsel. Every accused can engage advocate counsel of his choice. So, legal representation is a statutory right as well as a fundamental right under article 22 of the Indian Constitution. If accused who himself has committed crime cannot engage a counsel due to poverty, he is poor, and though he has committed crime, but because of presumption of innocence, he is presumed to be innocent unless his guilt is proved before the court of law. So, he can also get justice from the court, and case cannot be decided by the court in the absence of lawyer advocate. Every person has right to, and you see it would be injustice if a poor person is deprived from getting justice only because of poverty. He is poor, he cannot engage counsel in his defense. So, with this objective in the mind, with having all these idea in the mind, Supreme Court for the first time in M.H. Hoskot versus State of Maharashtra, EIR 1978, Supreme Court held that right to free legal aid is a fundamental right. Right to free legal aid is a fundamental right under article 21 of the Indian Constitution, and a person who is poor is unable to have a counsel due to poverty, he must be provided counsel free of cost by the government. Since then, so you see, in 1987 Parliament enacted a special legislation for that, right to free legal aid, right to speedy trial. You see how Supreme Court recognized right to speedy trial as a fundamental right under article 21 in Hussain Ara Khatun versus State of Bihar, EIR 1980 Supreme Court. In Hussain Ara Khatun case, where Hussain Ara she was also accused and she was languishing in jail for several years, and when matter was brought into the notice of Supreme Court held that right to speedy trial is a fundamental right under article 21 of the Indian Constitution, because there is a maxim, the justice delayed is justice denied. If justice is delayed, that is denial of justice. So, having this idea, Supreme Court held that right to speedy trial is a fundamental right, and that is integral part of right to life or personal liberty. So, with this I think I have covered each and every aspect of judiciary, and I have highlighted all the relevant case laws where Supreme Court has played significant role in protecting rights of the citizen of this country. With the help of judicial pronouncement, you can justify your argument that our Supreme Court has been effective in recognizing human rights as well as in protecting human rights of the citizen of this country. So, with this I would like to conclude my lecture. Thank you.